everyone. The Senate Labor Committee is called to order. I am first wanting to apologize to all of you. I'm sorry to have kept you waiting. My previous meeting went over and I hadn't realized how much time had elapsed, so I'm very sorry for keeping you all waiting. Thank you very much for all being here. First on our agenda today, I'm not sure it's important to note this or not. Well, I guess it is. We do have a quorum for the record. And first up on our agenda today, we have Workers' Compensation Court of Appeals overview. And so we are ready to proceed with that. We're going to receive our overview from Chief Judge Patricia Milun, if I'm pronouncing that correctly.
Yeah. Would you like me to come forward?
Please do. Please come forward. Thank you very much for being here. We look forward to hearing the overview and welcome. I also want to welcome you to the Labor Committee.
Thank you.
You can proceed whenever you're ready.
Well, Madam Chair, I am here today and thrilled to be here to provide a history, overview, and if asked, budget of our court. Historically, the WCCA is a newcomer to the game. Workers' compensation system has been in place for, as you know, many, many years. But in 1981, the legislature, through 175A, created the Workers' Compensation Court of Appeals. And in doing so, they put the appellate level process into the system whereby the original claims, disputes filed at the Department of Labor and Industry and are usually settled there or handled there, then proceed to the Office of Administrative Hearings for hearings on the record. And when parties become dissatisfied either with the decisions through the Department of Labor and Industry or OAH, that person, entity, can appeal to the appellate level, which is the WCCA. Any party dissatisfied with our decisions may proceed to the Minnesota Supreme Court. Having said that, I would then move to a general overview that has been attached to my letter and is also part of the agency profile. 5 judges sit in different panels at the WCCA. We have statewide jurisdiction to hear direct appeals from DOLI, OAH, and the arbitration, workers' compensation union. Those are far and few between, but they're housed initially in a proceeding element at the Department of Labor and Industry as well. The legislature has given us original jurisdiction to hear petitions to vacate settlement agreements. These settlement agreements can come at any time, in any decade, and that original jurisdiction carries with it a different direct analysis through this court as we consider whether or not to vacate, remand back to a lower court for further findings of fact, or make other decisions necessary under 175A. Our budget is 100% funded by the Workers' Compensation Fund. There are no general funds. There are no revolving funds. And we continue to operate, I believe, in a very fiscally responsible manner. We all do different jobs and wear different hats there. We have 5 judges, 5 staff attorneys, and 2 full-time employees. I would be happy to take any questions regarding the history, overview, or budget, if there are any.
Thank you very much. Appreciate the overview. And members, if you have looked in your packets, you'll see the information that we've received also in regard to the Workers' Compensation Court of Appeals and some of the background information that's been provided to us there as well. Are there any questions right now for Chief Judge Milun? Yes, Senator Pratt.
Thank you, Madam Chair. And Chief Judge, it has nothing to do with your confirmation, but since you're here, I thought I'd ask real quick. I know Department of Labor was updating their workers' comp software and platform. I'm wondering if you've seen an increase or decrease in number of complaints coming before you.
Chief Judge.
Thank you. We see challenges that are not insurmountable. We have been working collectively with the group running the data system called Campus. We are also been working in tandem with the Office of Administrative Hearings, running a system under C-Track. And the Minnesota Supreme Court, we are also providing within the form required by them for appeals under a C-Track system. So the challenges are not insurmountable. I think they're a good indicator of what we can do better. And I think they're an indicator to continue to provide equal access to those in the system as we move out of the paper world, which is difficult for us for many reasons, and move into a system for e-filing, e-service, and the collection of data.
Senator Pratt, follow-up?
Thank you, Madam Chair, and thank you, Your Honor. I appreciate that. So what we're really looking at is maybe fewer challenges, but maybe some more efficiency is what I think I hear you saying.
Yes. I wish I could have said it as succinctly as you have.
Thank you. Any follow-up? Okay. Members, any other questions for Chief Judge Milun? Okay, at this time, thank you very much for the presentation. I would also like to welcome the rest of the judges who have joined us this afternoon to the Senate Labor Committee. Also here we have today Judge Deborah Sundquist. If you wanted to go ahead and come up when I introduce you, that would be great. Judge Sean Quinn, Judge Thomas Christenson, and Judge Kathryn Carlson. Yeah, please come on up to the, we only have, oh, thank you. They're bringing up some more chairs here, so you can all sit there. Yes, if you would, that'd be wonderful. Okay. Thank you.
Okay.
And I will note as just a matter of procedure, so we're all on the same page, Judge Quinn has just been reappointed by Governor Walz, and so we do have the reappointment, but procedurally we haven't had the reappointment referred to the Labor Committee yet, so today we won't actually be taking up the motion on Judge Quinn's appointment on the Labor Committee, but we will do that as soon as we receive the paperwork. It's sort of a paperwork matter, so when we make the motion later, we won't include Judge Quinn's name for today, but we will act today as if we're doing all of the appointments together. So welcome all of you to the Senate Labor Committee. It's wonderful to see you, and we thank you very much for taking the time out of your busy schedules to come and meet our Labor Committee for this process. We really appreciate it. So if we could just briefly go down, if you could just take a moment to introduce yourselves to the Labor Committee, and then we can also see if members have any questions for you before we go ahead and make the motion to recommend appointment.
Good afternoon, Madam Chair, members of the committee. My name is Deb Sundquist. I have been a judge on the Workers' Compensation Court of Appeals for 10 years now. I was appointed by Governor Dayton in 2015, was confirmed by the Senate, and then reappointed by Governor Walz in 2021. Before that, I was a partner at the Offutt 40 law firm where I represented primarily Minnesota employers. I was on multiple committees there, was a chairperson of the Minnesota Defense Lawyers Association, Workers' Compensation Section. I've recently been appointed as a fellow for the the College of Workers' Compensation Lawyers. And before that, I served our nation in the United States Army Reserve as a JAG officer. As far as this job is concerned, I love it. It's an incredible job. I'm just thrilled to be a judge on this court. I am surrounded by incredibly smart people who were leaders in the workers' compensation bar and the court before being appointed to our court. And I want you to know that this is a very imperative point, that because they were leaders, they share a common knowledge of what is so important in workers' compensation, which is a hybrid law of both legal and medical issues. And all of the members of our court have a very good understanding of both. I seek your confirmation today, as well as the confirmation of all my colleagues here. I'm open for questions.
Thank you.
Thank you, Madam Chair, committee members. My name is Kathryn Carlson. I've been a judge on the Workers' Compensation Court of Appeal since October of 2023. I was appointed by Governor Walz. I am the junior member of this court. Before coming to the court, I practiced in the area of workers' compensation for over 30 years. I represented both injured workers and employers and insurers, some self-insured, some insured, some uninsured, through all corners of the state of Minnesota. I have been a repeat chair, co-chair, and speaker at workers' compensation CLEs. I've authored many publications regarding workers' compensation. Like Judge Sundquist, I am thrilled to be a member of this court. Every day I show up and work with people that really care about getting the best product out for the people of the state of Minnesota. And every day that I walk in and my badge still works, I have a little celebration. And I also appreciate your consideration of our nomination approval. Thank you very much.
Thank you.
My name is Patty Milun. That's what my friends call me. Please feel free to do so. I am the chief judge appointed first by Governor Dayton and reappointed by Governor Dayton and recently appointed by Governor Walz. I wanted to talk a little bit not only about the steep learning curve, but the actual law itself, because date of injury controls, to have this type of collaborative court on a panel court. There is really a distinction from a trial court to a panel court, especially at the appellate level. The collaboration, the robust discussions, the ability to have a difference of opinion without an ad hominem attack. We all sit here with different but similar backgrounds in our professions, and yet we all come to the table with shoulder to shoulder with an equal power base, and we have, I believe, served the people of Minnesota, the injured workers, Minnesota employers, with a passionate understanding of the law, of the injuries, of the premiums that we know move into a complicated mechanism for continuation to do business in the state. The public policies we are also aware of too. We've represented all of them. And I would just say that I am eternally grateful for this rewarding responsibility. And I ask that you confirm me and my colleagues as well. Thank you.
Thank you.
Thank you, everyone. My name is Sean Quinn. I was appointed to the court yesterday. Also 6 years before that and 9 months before that. Other than the highlights of Judge Sundquist's career, I could parrot everything else that the other three said, so I'm not going to be repetitive there. The one thing I would add is that being a member of the court has given me a platform to try to grow understanding of workers' comp among young lawyers. I'm teaching workers' comp now at the University of Minnesota. It took 2 years to develop the program through the faculty there to get them to agree to the syllabus and all of those things. Just had my first class this past fall. It went terrifically. I've joined a number of different smaller bar associations to try to encourage young lawyers and young law students to engage in workers' comp as a career because when I was a law student, I thought, oh my God, I will never do that. That is horrible, how boring, yuck. And then you get a job and the law firm that hires you does workers' comp, so all of a sudden you do workers' comp. And then you find out how interesting it is and how fascinating it is and how important it is. And so the role as a judge gives me that opportunity to try to spread the word, as it were. So anyway, I appreciate your consideration. I understand the procedure regarding my vote today, so I was forewarned of that, so that's understandable. So anyway, thank you very much.
Thank you.
Good afternoon, Madam Chair, members of the Labor Committee. My name is Tom Christenson. I've been on the Workers' Compensation Court of Appeals since 2022, coming on 3 years. I think you've all seen my resume, and I'm not going to try to repeat what I said last year in March. But what I want to leave the members of the committee with and all of you is that, as you can see, we're all very collegial, collaborative in what we do each and every day. We are, as stated before, a panel court. In other words, we have to work together each and every day on every decision that comes out, which we work very hard to get right all of the time. And we work together on that, not only with ourselves, the 5 judges that you see here before you today, but we have 5 wonderful staff attorneys and 2 administrative staff that do a wonderful job for us. It's been a privilege and honor to do this work on behalf of the citizens of the state of Minnesota, and I would ask that you recommend me for appointment to the position, as well as all of the other judges, and when Judge Quinn's time comes, he also be recommended and approved by the full Senate. Thank you very much, and thank you for your time this afternoon.
Thank you all very much. Senator Pappas.
Thank you, Madam Chair. Just a clarification, since we have Judge Quinn's paperwork here, what's holding up the recommendation?
Thank you for that question, Senator Pappas. That was my question as well. And my understanding, what I've been told, is that we actually need that appointment. We have a copy of the paperwork, but the Senate body has not referred it officially to our committee yet.
I got it.
So once that happens, we'll take that up right away.
Thank you.
Thank you for that question. Yeah. Members, yes, Senator Brett.
Thank you, Madam Chair. And I'm just curious if you can tell me approximately how many cases do you guys hear a month, a year? I'm just trying to figure out the volume that the court has.
I'll just turn it over to whoever chooses to
Thank
answer.
you. When you say here, I guess I would divide that to understand a little bit more. You're saying that come in through either OH, Dolly, or the arbitration, right? Okay. Those cases come in and out, and if you look at our agency profile, you can see that we are in the process of redrafting the data for the affected parties, and one of the reasons is because of the change in campus and the physicality of not having a banker's box delivered to our office with the case at hand. So while the numbers have statistically gone down, the cases generally have a wax and wane if you look throughout the fiscal year since the inception of the WCCA in 1981. As the law moves forward and we have new laws, people want to test it until such time it's become well established, either all the way up to the Supreme Court. Right now, the caseload is significantly lower, and I would be happy after this meeting to get you or any of the members here a printout of the actual cases moving through for whatever period of time you're interested in. Could I ask you for a time?
Sure.
Okay.
Senator Pratt.
Thank you, Madam Chair. That's fine. I was just kind of curious. You're one of those agencies that not many people know about until they have to go in front of you, and I'm just kind of curious as, what kind of caseload does a judge normally see? And so it was more out of curiosity than anything else. Thank you.
Yeah. Thank you, Senator. Members, any other questions for our Workers' Compensation Court of Appeals judges? Yes, Senator Wiesenberg.
Thank you, Madam Chair. I have, I guess, a question because I don't understand how workers' comp works. So one would be, I'll ask a question and explain why I'm asking it. How long does it take for someone to get the money they're owed, I guess, if they're injured on the job? So, and so my father, who was a baker for 45 years, was injured because of his job. Basically, they carpal tunnel in your neck because you're always down and doing this with your hands. So he was fighting to get workers' comp, and it took a long time, and he couldn't get it. And then he even had surgery on his neck. So, he literally had surgery because he couldn't move, and he still didn't have workers' compensation. So eventually, my dad died, and then finally my mom had to go after my father died to get back pay. That just seems something that is so out of realm that shouldn't be happening. So I don't know if you can explain to me why that happened. I'm not blaming you. I'm just, this happened. So why did that happen?
Thanks for that question. And I appreciate the question because sometimes in a confirmation hearing like this, we will be talking about more technical issues or the number of cases that you hear and things like that. But I think that a question such as the one that Senator Wiesenberg is posing is the type of question that a lot of people just have about workers' compensation and how it works and some of the things that people hear maybe just through their networks of things that happen to people. So any information you're willing to share about just how the workers' compensation system might work in terms of length or time, I think could help provide some good information for people. Thanks.
Thank you, Madam Chair. First of all, I'm very sorry for your loss. That is a significant experience that I would wish on no one. The system was initiated to remove negligence and to move the benefit package for injured workers through the system expeditiously. And in doing so, they removed it out of a negligence or, intentional, whether or not there was an intentionality to the injury. So it became a no-fault system. The admission of liability for an injury is a very short time period that the insurer can have to file that form at the Department of Labor and Industry. The continuation of that liability through discovery can take too long and perhaps not long enough. In your case, I'm wondering where that case ended up in the whole system. Did it stay at the Department of Labor and Industry for the initial request? Did it move by attorney or by pro se to a formal hearing at the Office of Administrative Hearings? Did it move from there to the Workers' Comp Court of Appeals? Did it try to settle? And then the dependency benefits, again, that's the tag on. I wish I had the answer for you, but I know that my colleague, Judge Quinn, well, that was a Freudian slip, is chomping at the bit to answer that because he, like some of my other colleagues, practiced and represented injured workers to a greater percentage than those of us here. So can I give the microphone to you?
Thank you. I'm going to speak frankly.
Please do.
And I represented injured workers for 30 years. I don't know, and I know that with the testimony, it's kind of a weird back and forth here, but I don't know if your father hired a lawyer. But what you're describing for your father was what we call a Gillette injury, which is a repetitive trauma injury. You do something over and over for weeks, months, years, decades, and eventually your neck hurts, probably because he was bent over forward like that for so many years. Insurance companies rarely, I don't want to say never, although I would like to say never, but rarely admit a Gillette injury. They make the employee prove it. The burden of proving a Gillette injury is no different than the burden of proving any other injury that, I got hit by a 2x4 and broke my arm kind of injury. But it requires, substantial medical proof. Typically, you got to have your treating doctor or a hired expert say, yeah, this is related, review all the records, so forth. If your father hired a lawyer and filed a claim, the typical, from the beginning of a work comp claim to the end of a work comp claim, is typically somewhere in the neighborhood of a year to a year and a half. Every once in a while it goes a little bit longer. But that is rare. So I'm not exactly, and I'm happy to talk to you after we adjourn more about it. But that's a typical process. I suspect from what you've described that there was either he didn't hire a lawyer right away, or perhaps he hired a less than stellar lawyer right away, and the claim didn't get filed quick enough. And they kept hoping, or maybe they weren't getting the medical proof that they needed. I'm not exactly sure. Those kind of horror stories are things I dealt with a lot in my career, and they were awful. And there's no justification for it. It's just, but that's why you need good representation.
Thank you, Judge. Follow-up, Senator
Yeah, Madam
Biesenberg?
Chair, and thank you for the answer. And I don't want to, it's not about me, it's about, because this is not just my dad, it's happened to other people,
Right.
right? And we need to make sure these things don't happen. How do we do that, right? Because it's like, he had surgery on his neck from his job, and he literally had plates in his neck. So it's like, well, that seems like proof, right? Because you can't move. Or if your arm gets chopped off with a chainsaw, whatever, right? That's proof, I would think. So why do we have to, I remember, like, it's like, well, how do we know? Well, because the repetitiveness of 45 years of looking down and doing this, that's what happened, right? So, and like I said, eventually it got settled, but it just didn't, it just seemed like it took too long for something that seemed very obvious, right? So, but thank you. It's just, however we move forward and help people, we got to do that.
Agreed.
Right, thank you.
Thanks for sharing that, Senator. Any other questions or comments for our panel today of judges? I will just say thank you very much to all of you for coming here today and for introducing yourselves again. I know we're repeating from last year as well. And I just appreciate and want to extend a thank you to you for upholding the integrity of our court system and that balance and playing that really important role of carrying out our laws to the best of your ability with this unbiased and clear-headed way. And it sounds like a really neat experience, and also different than what people might be used to, talking about courts of law and judges making decisions, to have a panel like this. So thanks for educating us about that as well. It sounds like a wonderful collaborative working relationship you all have together. Anything further before we hear a motion? Okay, Senator Dornick, are you ready to make a motion?
Thank you, Madam Chair. I move to recommend to the Senate that the appointment of Chief Justice Patricia J. Milun, Judge Deborah K. Sundquist, Judge Thomas J. Christenson, and Judge Kathryn H. Carlson to the Workers' Compensation Court of Appeals be confirmed.
Thank you, Senator Co-Chair Dornick. Members, all in favor of Senator Dornick's motion, please say aye. Aye. Any opposed? Right. The motion carries unanimously and is passed. Thank you all very much for joining us today. Yes, Senator Marty.
I just wanted to ask, and I don't want to speak for the rest of the committee, but it sounds like Judge Quinn will be, this was his hearing. I just want to make sure that we can tell him he doesn't have to show up for the paperwork move, because otherwise I think people getting confirmed feel they ought to show up when there's a vote happening. And unless anybody on the committee wants to ask more questions, I think it would be appropriate to tell him he does not have to come.
Thank you, Senator Marty. Would any member of the committee wish to offer any counter opinion to that? Otherwise, we will inform Judge Quinn that he does not need to reappear when we move the paperwork through. Okay, I think there's a unanimous agreement on that.
All right,
Thank you.
I hate wearing a tie, so I appreciate it.
Thank you all very much. Appreciate it. Thank you. Next, members, we have a Bureau of Mediation Services overview, which we're going to receive from Commissioner Johnny Villarreal. Good afternoon, Commissioner. Thank you so much for coming to the Senate Labor Committee to give us an overview today. I will hand it over to you.
Thank you. Good afternoon, Madam Chair and committee members. My name is Johnny Villarreal, and I am the Commissioner of the Bureau of Mediation Services. I'm joined by our program coordinator, Tom Shoemaker, who wears many hats for us, but today's acting in his capacity as our legislative liaison. Thank you again for the opportunity to provide an agency overview to highlight the great work our staff provides to the state of Minnesota. The Bureau is a neutral agency that's existed for nearly a century, established in 1939 under the Minnesota Labor Relations Act. In 1971, the Public Employment Labor Relations Act established the agency's mission, which is to promote orderly and constructive relationships between public employers and employees. Bureau has limited authority to order the release of certain personnel data under the Data Practices Act, and we took on the administration of the Peace Officer Grievance Arbitration Roster, or POGAR, in 2020. Our stakeholders include public employers, employees, and unions from across the four corners of the state, including over 850 cities and townships, the 87 counties, over 300 school districts, and more than 40,000 state executive and judicial branch employees. We also work with boards and commissions, joint powers, public nursing homes, public utilities, and charitable hospitals. 100% of the agency budget comes from the general fund with no federal or grant money passed through. As you can see from our org chart, we have a small but mighty team of well-educated staff who are motivated to help our stakeholders manage conflict. We currently have 6 mediators with a working commissioner and deputy, and 3 mediators are also serving as hearing officers, investigating and adjudicating representation cases. We recently hired the agency's first general counsel, who manages our rep and arbitration work and data practices, internal controls, and any other legal issues that may arise. 75% of our staff has 5 years or less with the agency after several recent retirements. So we've invested in professional development that includes CLEs, Rule 114 training, and peer agency conferences such as ALRA and LIRA. These are the programs, some of the programs that we administer, and we'll cover them in more detail on the next slides. Mediation cases encompass the largest portion of the agency's workload. In FY23, we processed 349 mediation cases, and in FY24, 367 cases. Grievance mediations usually require mutual agreement to participate, and we resolve more than 80% of those cases. More than half of our mediation cases are contract cases, and a petition for contract mediation can sometimes start timelines for impasse, and we settle more than 90% of those cases prior to a strike or an arbitration and interest arbitration. So speaking about strikes, the information here depicts the number of strike notices and strikes occurring by decade in the state of Minnesota. The percentage on the right reflects the notices where a strike occurred, And looking at that percentage another way, the agency was able to help the parties avoid a strike through mediation far more often. It may feel like strike actions are more prevalent in recent years, especially given high-profile strikes such as the Screen Actors Guild and UAW, Teamsters, Longshoremen, and others. And although we have seen an increase in notices and strikes in recent years, the numbers are nowhere near the numbers seen in the 80s and 90s. There's several types of representation questions that the agency investigates based on employees' right to organize under the statute. And in FY 23 and 24, the agency processed 116 unit determination and certification cases, which involves brand new units. We processed 9 decertification cases where employees voted to have no representation. And there were 191 unit clarification cases where positions were either identified to be included or excluded from an existing bargaining unit based on the facts of the case. Some other types of cases include challenges by one union against another, voluntary transfer from one union to another, division of a licensed and non-licensed essential unit, and then the relatively new unit merger process passed into law last year. Our training program has really improved over the past few years thanks to mediator Marshall Thompson, who has a background in education. We've seen an increase in both Labor Management Committee and interest-based collective bargaining requests based on that positive feedback from our stakeholders. And in FY 23 and 24, we processed 114 LMC cases and 14 IBCB cases. Our trainings the agencies provided in the past include topics such as PELRA, mediation, representation, and committee effectiveness training. And we're very excited about a new training we're working on in collaboration with the Federal Mediation and Conciliation Service, or FMCS, and it's called Path Forward Discussion. BMS staff recently spent a full day with FMCS staff to learn more about the program and ways we can offer this to our stakeholders. The initial concept used by FMCS was to help parties move forward in a positive way after a highly contentious bargaining experience, and BMS believes we can use this program at the beginning of bargaining as well to help the parties better communicate and help lower the temperature at the bargaining table. We hope to have this training available for contracts expiring sometime this year. The BMS has a main roster of arbitrators with a minimum of 25 and a maximum of 60 arbitrators, and we're currently at 43. Stakeholders get a random list of arbitrators from our main roster from the Bureau, and then they strike names until one's selected. Our main roster of arbitrators can hear either grievance cases other than peace officer grievances or contract or interest cases, and we issued 425 lists over FYs 23 and 24. Peace officer grievances are heard by POGAR, which has 6 arbitrators that are selected by alphabetical rotation under the law. Arbitrators from POGAR were assigned 13 cases from FY 23 to 24. While arbitrators on the list are not Bureau employees, their decisions are binding on both parties. I'd like to wrap up our agency overview by highlighting some initiatives that we're undertaking. Once a month, my leadership team and I make ourselves available in a hybrid setting to discuss agency operations and any issues or concerns from stakeholders, and we call it Coffee with the Commissioner. We meet with management representatives on the 3rd Wednesday of odd-numbered months and labor representatives on the even-numbered months. It's been a great opportunity to check in with our stakeholders. The legislature gave the agency expedited rulemaking authority last session to address majority verification. However, we chose to go through the traditional rulemaking process to address other changes in the statute, such as unit merger and some other recommendations from our stakeholders. We'll look to post that 60-day public comment period soon, and we'll have updates listed on our website as we go through that process. Last session, the legislature changed the law regarding training for POGAR arbitrators to be paid by the agency instead of the arbitrators. and we've coordinated with Hennepin Technical College to develop a curriculum for the POGAR training. The law requires at least 6 hours of law enforcement and 6 hours of cultural competency-related training, and previous training was inconsistent and less effective. So Hennepin Technical College worked with their law enforcement curriculum and community leaders to develop 2 full days of training. Lastly, the agency is using Odyssey funds to provide updates to our case management system, and these updates will provide better data reports for the agency and will enhance stakeholder experience. Again, thank you to the committee for the opportunity to highlight the work of the Bureau. We're a small agency with a dedicated staff that has a big impact on the lives of Minnesotans. We look forward to working with you over the next biennium, and I'll stand for any questions.
Thank you very much, Commissioner. Members, in just a moment, we're going to move to confirmation of the commissioner as well. But at this point, I'd like to just keep things to questions or comments regarding the overview of the Bureau that we just had. Do people have questions or comments related to the overview? Any questions? Yes, Senator Pratt.
Thank you, Madam Chair and Commissioner. Nice to see you again. You know, Madam Chair, I got to say this has always been one of the agencies that I've found most interesting. They seem to be one of the smallest agencies in state government, and yet the impact, and we can see it here with just, you know, some of the strike trends and other data, the impact that they have. And I know they work very hard. If I recall, Commissioner, you're still doing mediation sessions as well.
Commissioner?
Madam Chair and Senator Pratt, yes, working commissioner and deputy commissioner.
So,
Senator? Yeah.
I think it's interesting that how this agency works, and I just thought members would like to know, and appreciation to the commissioner for being on the front lines and listening to these issues.
Thank you, Senator. Hear, hear. Any further questions or comments? Okay, thank you very much for the overview, Commissioner. At this time, and thank you, Mr. Schumacher, also for being available. Next, we'll move to confirmation of Commissioner Villarreal, and thank you for continuing to stay with us. Are there any comments that you would like to offer the committee in regard to your confirmation before we move to discussion on that topic?
Thank you, Madam Chair and committee members. I do have just a few comments. I want to thank the committee for the opportunity to be here to introduce myself again. I started my public service as a part-time school bus driver in the Robbinsdale School District, and as a union bargaining team member, I participated in mediation several times and watched the mediators help us find common ground and reach agreement. And I knew that's what I wanted to do with my life. I spent time as a lead negotiator for 2 unions, first with SEIU 284 and then with MAPE. And while working with MAPE, I became Rule 114 qualified as a mediator in the state of Minnesota. And in 2007, I applied for an open position as a mediator with the Bureau under the Palenti administration, and I accepted that position in July of that year. In 2010, I had a midlife crisis and joined the Minnesota Army National Guard as another way to publicly serve. I completed basic training at 39 and commissioned as an officer at age 40. Deployed to Afghanistan in 2018 as a company commander working casualty operations, and served as the director of BOSS-I in 2022 and 23 at Al-Assad Air Base in Al-Anbar province. As covered in our agency overview, the mission of the Bureau is to promote stable and constructive labor relations in the state of Minnesota. Our agency does our best to help people get through uncertain times and difficult times. I'll continue to do everything I can to use my more than 2 decades of experience in labor relations and my 15 years in the National Guard to lead a staff that's highly skilled and highly motivated to help. Thank you for your time and consideration, and I'll stand for any questions.
Thank you very much, Commissioner. Members, is there any discussion or questions that anyone has for Commissioner Villarreal? Okay. And I'll note that we have occasion to hear from you, so I'm not surprised that people don't really have anything for you right now, but we do see you on an ongoing basis. All right, well, I thank you very much for all of your work, and thank you for coming and making the time today to give us the overview and also to come today for the confirmation proceeding. And if there are no other questions or comments, Senator Dornick, would you like to make the motion?
Thank you, Madam Chair. I move to recommend to the Senate that the appointment of Johnny Villarreal as Commissioner of the Bureau of Mediation Service be confirmed.
Thank you, Senator. On that motion, all those in favor, please say aye. Aye. Any opposed, say nay. All right, the motion to recommend to the Senate that the appointment of Johnny Villarreal as Commissioner of the Bureau of Mediation Services be confirmed does pass. Thank you very much. Thank you, members. Next and finally on our agenda today is a Public Employment Relations Board overview. Welcome to the Senate Labor Committee today.
Hi, good.
Thank you for coming.
Yeah, I get my PowerPoint.
Excellent.
Yes.
Thank you. If you would go ahead and introduce yourself for the record and then proceed. Thank you.
Good afternoon, Madam Chair and members of the committee. Thank you for the opportunity to provide an overview of the Public Employment Relations Board. My name is Jess Anna King, and I'm the Executive Director and General Counsel for the PERB. I'm also joined today by Meg Luger-Nicolai. Meg is a board member representing public employees. Today, you will hear a bit of the who, what, and where for PERB, and a bit of history, a bunch of the here and now, and a bit of the future. Meg and I are both available for questions. The Public Employment Labor Relations Act, or PELRA, at Chapter 179A, promotes orderly and constructive relationships between public employers and public employees for the benefit of Minnesotans. The public sector is guaranteeing the health, education, safety, and welfare of the public. The need for cooperation is different than what's needed in the private sector, and PELRA provides the rules of the road for those relationships. Along with the BMS, the PERB are the front lines of PELRA. Disputes happen. Unresolved disputes can cause injury to the parties and to the public. The disputes under PELRA are resolved in one of two ways. Number one, if the dispute is about the formation of a bargaining unit, for example, it's resolved through the BMS with a unit clarification proceeding or an unfair election practice charge. Number two, if the dispute is about whether a party violated provisions of PELRA in the midst of an existing union relationship, it goes to the PERB. The PERB is the agency that handles public sector unfair labor practices. So what are unfair labor practices? They're defined in Minnesota Statute 179A13. For public employers, it could be interfering with an attempt to form or run a labor union, terminating or disciplining an employee for their union activities, refusing to bargain with a union, or refusing to comply with grievance procedures, for example. For unions, unfair labor practices could include forcing someone to join a union, refusing to negotiate, refusing to comply with an arbitrator's award, or picketing that interferes with deliveries to facilities of the employer. As you can probably imagine, listening to this list of examples, these disputes are part of a fairly specialized area of law. However, without the PERB, unfair labor practice cases must go to district courts. That pathway was viewed as inefficient and expensive for the parties, especially for workers. Additionally, Minnesota judges do not have the capacity to develop the expertise in labor disputes because they just don't occur in their courtrooms with sufficient frequency. In 2014, advocates began considering whether there was a way to give public sector labor disputes a specialized forum similar to the system that exists in the private sector. The legislature created the PERB, an administrative body to which the legislature delegated the investigation and resolution of unfair labor practices. The PERB was given agency startup funding as of July 1, 2014, and a modest budget allocation of $125,000 for that startup. What followed was a series of amendments pushing out the date for the PERB's jurisdiction. Until finally in 2020, the legislators did not reach an agreement on funding or deferring the implementation date for the statute, so the PERB opened its doors for charges on July 1, 2020. Without any full-time staff, the PERB received 31 charges, requiring varying levels of action on the part of very supportive BMS staff, very part-time PERB staff, and tireless board members. PERB's jurisdiction ended again on June 30th, 2021, in a legislative agreement that left our funding at $125,000 and jurisdiction on hold until July 1, 2023. Public sector employers and unions were back to court to sort out allegations of unfair labor practices. However, as of July 1, 2023, the PERB had both jurisdiction and actual startup funding to staff and operate. In fiscal year 24, we docketed on average 1 charge a week, with a fiscal year total of 63 charges. In fiscal year 25, we expect to go beyond that number. As of today, we've docketed a total of 46 charges. You can see in that chart, this is where I predict the future. Some projected numbers, looking at the timelines and what we've received thus far. So who's filing charges? Unions are filing charges against employers. Employers are charging against employees. Employers are charging against unions. Employees are charging against the employer, and individual employees are charging against the union. The charging parties are firefighters, nurses, educators, park maintenance workers, and state professional employees. Some are in units of 600, some are in units of 6. Some are cities, some are counties. The charges are coming out of different areas of the state, from Hibbing and Rice Lake to Moorhead and Lyon, Dakota, Fillmore, McLeod counties, Bemidji, St. Paul, and Hennepin County. Charges allege different violations of the law, everything from refusing to bargain or strike activities to allegations that get at the intersections of speech and coercion or interference. Many are cases of first impression. Notably, these are live disputes, meaning they're happening right now. PELRA has a 6-month statute of limitations on ULPs. That's why the resolution of charges is so important. Unlike lots of parties that end up in court, these parties before the PERB have ongoing relationships, important relationships that work to benefit the public. The PERB's work in investigation and resolution of unfair labor practices that arise during conflicts in those relationships. It's not just to process and write decisions. Many cases are resolved while the PERB is investigating. Parties are digging in on evidence and research. They're talking with their lawyers and their folks. And a large number of cases are withdrawn after board decision to dismiss, something provided for in our rules. Some are resolved through mediation with PERB staff, me working as their mediator. And yes, some receive orders, final decisions from the board. So who are the PERB decision makers? The board is 3 members and 3 alternates. The composition has a unique setup that ensures neutrality. The governor appoints the employee or union representative members. The governor appoints the employer or management representative members. Then the union and management members select the neutral members of the board. The current board is made up of some of the most brilliant, close your ears, Nick, some of the most brilliant legal minds in the state of Minnesota. They each have between 20 and 40 plus years of experience. That means the least experience has more than 20 years of labor law experience. They work incredibly hard to get it right, to educate parties and the labor community in Minnesota. They consider and reconsider, they push and pull at each other. It's a real personal honor for me to work with these board members. Okay, now you can listen. The staff support the board throughout and fulfill the mandate regarding investigations. You can see our staff makeup is small but mighty, not unlike the BMS who we collaborate with. Operations under the statute requires an investigation of any charge charge filed, That requires us to review and investigate charges and party submissions, for the board to make an initial determination as to whether the charge has, in the language of the statute, a reasonable basis in law or fact. If it does not, the board will vote to dismiss. The charging party will receive notice and have the option to withdraw the charge or receive a dismissal order detailing the board's findings and rationale. If the charge does have a reasonable basis in law or fact, a complaint is issued, followed by an evidentiary hearing with a hearing officer hired by the board. The hearing officer then writes a recommended decision for the board, and the board can adopt, reject, or modify that recommended decision in the board's decision and order. After a complaint, the burden on the parties increases because it includes the hearing and the briefing and the possibility exceptions to the hearing officer recommendation or even coming before the board. That is another reason we see resolutions happen when and as much as they do. Notably, unlike the National Labor Relations Board, the PIRB is neutral throughout. We never act as prosecutor of the charges. The parties must prove and defend their own cases. The PIRB will be judged by its stakeholders based on its neutrality and efficiency. And neutrality is built into our structure and our practices. We're working on efficiency as staff are hired and learning our roles. So that's my overview. Thank you for your investment in the PIRB. It is an investment in your public employers and your public employees, and a good investment of public dollars. Every employer has disputes, but not everyone has a big budget to spend on courtroom battles to resolve these disputes. Spending government dollars for services to Minnesotans rather than legal battles in court is cost efficient. The PIRB is a cheaper model for resolving disputes and facilitates expert consideration and resolution for those ongoing relationships involved in labor management. Along with the BMS, we are the front lines of PELRA. We are part of a strategy and a public purpose to support labor peace and efficient resolution of issues. Thank you, and we're happy to answer questions.
Thank you very much for that overview. Members, I'm going to open it up for any questions or comments that anyone may have for our Executive Director and General Counsel of the PIRB. Yes, Senator Pappas.
Thank you, Madam Chair, and thank you for that overview of the history. It was a rough journey to get where you are now, but I'm just really pleased to see that you're up and running and doing such a great job. So thank you.
Thank you. Thank you. Yes, Senator Kupek.
Thank you, Madam Chair. I will piggyback off of Senator Pappas's comments because I know she had the original bill to establish this, and then 2 years ago I carried the bill to get the funding. And it was, when it was presented to me, it was also the fact that this is a savings for workers who don't have to hire an attorney, and it's also a savings for the government because they also do not have to spend money with cases tied up in court, and resolution comes faster as well than it would in a court case. So it was a win-win situation, and I'm glad to see things seem like they're going pretty well. So thank you.
Mm-hmm. Thank you, Senator.
Thank you, Senator. Yeah, any further comments, questions? Great. Well, I echo the appreciation for all of the work that you're doing, and I'm very, very pleased that you're taking so much of this load and actually working through all of these conflicts and things that happen in our public workplaces. And it seems like things are, I echo Senator Kupek, that things seem to be going along really well, and we're really grateful for the work that you do. I see no further comments or questions. So with that, we will conclude the overview. Are there any closing comments you wish to share?
No, thank you for the opportunity to come here today and share this work we're doing.
Thank you very much. Appreciate it. All right. That concludes our agenda for this afternoon, members. And with that, the Senate Labor Committee is adjourned.